In a recent turn of events, the government of JNK has turned rogue. It has started evicting the members of Gujjar and Bakarwal communities from their ancestral forest land. The instances of these evictions have been seen at Badgam, at Pahalgam, at Jammu, and at various other places. The apartments of these Gujars and Bakarwals have been razed down, their orchards have been chopped down. However, the human element of the whole affair puts the different complexion on the matter, which the apathetic authorities of the JNK have failed to address. In today's episode, we are going to discuss how these evictions are in violation of the constitutional spirit of the country and how it exploits the mandate of the government institutions. I am Abrar Ashraf on the Satyagraha for the Watchdog. When the former state of JNK was demoted to a centrally administered union territory, all the laws, all the ordinances, all the acts, all the rights were extended to the union territory by the virtue of that deed. But some reasons, the Forest Rights Act 2006 was not implemented in the union territory. For what reasons, we cannot say. But there are various assumptions doing the rounds in the political debate. And chief among them is this, that the government wants to disenfranchise the poor and impoverished of the state and open the place to the vultures. Now, why is this Forest Rights Act 2006, or in the legal jargon as it's called, the Scheduled Tribes and Traditional Forest Dwellers Recognition of Rights Act, important in the context of JNK evictions? There are four reasons. One, the act is immensely comprehensive and it recognizes and it is emphatic towards the forest dwellers. Second, it is the result of the arduous fight put up by the forest rights activists and by the 200 million forest dwellers of India. Third, the act is apologetic. It recognizes that there has been a historic injustice done towards the forest dwellers, that their rights have never been recognized, nor during the colonial era, nor in the independent India. And now fourth, the historic injustice that the Act speaks about is still in place in JNK because the Act has not been implemented. Because the Act is not in place. Therefore, the forest dwellers are without the legal remedy that the Act provides. The government of JNK has identified 63,000 individuals who are accused of encroaching 15,000 hectares of forest land. And how have they been recovering this land is through muscle, through sheer and brute force. The Forest Department of JNK has turned into a gang of goons. It's evident the identification that they have done is cosmetic and superficial. The Forest Rights Act also lays an emphasis on the identification of the encroachers and identification of the claimants who have a claim on the forest land. But they ought to be verified by the committees set up by the state or by a union territory. In JNK, these committees have not been formed. These committees have not verified the claims of the claimants over the forest land, neither have they identified the encroachers. As I said, the Forest Rights Act 2006 is comprehensive and emphatic. It recognizes that to establish the claims and to identify the encroachers, there must be some members from these forest dwelling communities in the committees identify the encroachers and that will identify the claimants. But in JNK, this process has happened in a very superficial and in a very cosmetic manner. On 13th February 2019, the Supreme Court of India ordered the eviction of 11.7 lakh forest dwellers whose claims were not identified by the committees. But on 28th February the same year, the SC stayed its own order on recognition of this fact that it was more of a human matter. It was more of a human issue than a legal one. Since the Supreme Court has already stated that the evictions of the forest dwellers is a human matter, is a human issue, the relief and rehabilitation of the evicted forest dwellers must always be kept in mind. But unfortunately, that has not happened in JNK. Also, the evicted forest dwellers have not been given time to approach a legal remedy and stake their claim. And this act by the JNK Forest Department or by the JNK authorities is unconstitutional and against the simple human decency. In conclusion, I would say that FRA, Forest Rights Act 2006, must be implemented in JandK because it's more comprehensive and it's more emphatic towards the forest dwellers. And second, I would say that before the authorities would venture to evict these forest dwellers from their forest dwellings, the relief and rehabilitation must be kept in mind. And third, I would say the government should form committees that will identify the encroachers and establish the claims of those who have been at the land for more than 3 generations and who have been at the land for 75 years, because their rights have to be recognized according to the Forest Rights Act 2006. These Gujar and Bakarwal communities are most underprivileged and most impoverished in JandK, and it's important, it's imperative that their voices are regarded. And if the government has to recover the encroached land, I would suggest that they begin with hoteliers, with the army, and with encroachments of the forest land by the companies with impeccable contracts and impeccable mining rights. So this was it for today. I'm Abrar Ashraf on Satyagraha for the Watchdog.